All right, let's get you the breaking news that's come in. A Delhi court has reserved its order on BRS leader K Kavitha's plea seeking interim bail in the Delhi excise policy case. The court will pronounce its verdict now on the 8th of April. So that's the latest coming in from the court. With regards to K Kavitha's plea seeking an interim bail, remember she's also lodged at Tihar jail along with others who've been accused in this case, including Delhi Chief Minister Arvind Kejriwal. But today, the court reserved its verdict and it is now expected to pronounce its verdict on the 8th of April. So clearly, trouble not ending anytime soon for BRS leader K Kavitha, who has been accused by the Enforcement Directorate in the alleged Delhi liquor policy scam. Because she, along with the Aam Aadmi Party leader Arvind Kejriwal as well as Manish Sisodia, remain in custody. Let me go across to my colleague Rame, who's joining us with more details on this. Rame, clearly no immediate relief for K Kavitha by the authorities, the court reserving its verdict. What exactly transpired in the court today during this hearing?
BRS leader K Kavitha had to move two applications. One was seeking interim bail and the other was regular bail. On the last date of the hearing, senior advocate Abhishek Manu Singhvi appeared for K Kavitha and he argued on the merits of the case. However, the ED objected this. ED stated that the application which was listed today was interim bail application. It was also noted in the judicial order that K Kavitha is seeking interim bail. Accordingly, the court granted time to counsels for K Kavitha to seek clarification that whether they want to argue on the interim bail application or whether they want to argue on the regular bail application. The matter was listed today. Now the court was clarified today that we would like to seek an interim bail for almost a month. The grounds given were that K Kavitha's minor son was having examinations and hence K Kavitha had to fulfill her duties as a mother, and on these grounds solely she sought interim bail. It was stated that after all of this arrest of her mother, the child was in somehow a shock and the child needed her mother, and K Kavitha has to go and fulfill her duties because examinations of for a child are very, very hectic and it has mental as well as psychological, emotional effect on a child. And at this stage, her mother is required and hence she requested the court to allow her the interim bail application. It was also stated that in case she is released, all the triple test of bail would be satisfied and whatsoever condition the court has to impose can impose, but she should be granted interim bail. While on the other hand, ED objected it very strongly. ED stated that K Kavitha is highly influential. She would tamper with the evidences. ED also stated that when we asked her for mobile phones, 4 or 5 mobile phones which she used during the past 2 years, she gave it to us, but all the data was deleted. She is already accused of tampering with the evidence. She has deleted the evidences, and if she is released on bail at such stage, then it would affect their investigation. They also stated that we are about to conclude our investigation, and if she is allowed the interim bail, it would cause grave prejudice. Noting this, the court reserved its order and it is likely to be pronounced on this coming Monday, April 8th.
All right, Rame, stay with us as we get our viewers an update from Arvind Kejriwal. In fact, there's been a minor relief for Arvind Kejriwal as he continues to battle his arrest in the Delhi Liquorgate case. The Delhi High Court has once again rejected a plea seeking the removal of Arvind Kejriwal as Delhi's chief minister. The court remarked that democracy should take its own course, adding that it cannot counsel or direct the lieutenant governor to take any action. But more importantly, the High Court also said the personal interest has to be subordinate to national interest, though it put the ball in Kejriwal's court to decide whether he wants to continue as the chief minister or resign from his post. Let me go back to my colleague Rame and try and understand what exactly happened in the court. Rame, the court saying that, national interest should be paramount to personal interest, but it really is Arvind Kejriwal's choice. Interesting statement by the court. They're not intervening, yet giving out a statement which has so many, perhaps interpretations in this case for Arvind Kejriwal.
Absolutely. So it is a well settled thing by now that there is no statute, there is no law which bars a person, which would bar Arvind Kejriwal to continue as a chief minister of Delhi despite being jailed, despite being in judicial custody, despite being an accused in the case. Remember, he is still an accused, not a convict. Now, this was a second public interest litigation moved before the Delhi High Court. Even earlier, a similar PIL was moved, which was dismissed. Even today, there was another PIL moved, which stated that Arvind Kejriwal should not continue as a chief minister of Delhi. This is absolutely hazard. This is a very bad detriment would be caused to the state, that a state chief minister is in jail and grave prejudice, great loss is being caused to the state people. So such submissions were made. However, the High Court remarked that this does not come under the domain of judiciary. We have stated it before, we are stating it again. This is not in our domain. Have you ever seen a court imposing national emergency in a state, or a court directing a lieutenant governor or the president to impose national emergency? Have you ever seen such thing? So how can we tell the lieutenant governor or the president to impose emergency in the state and to remove Arvind Kejriwal from the post of CM? This does not concern the judiciary, but the other organs of our country, executive. This concerns them. The High Court also made one oral remark. High Court stated that ultimately it's Arvind Kejriwal's choice. Now he has to see which interest should be put first. Is it his personal interest or is it national interest? The High Court hinted that absolutely it gets difficult to run a government from the jail. But howsoever, it is his personal choice now, that whether he would want to continue or whether he does not want to continue. So leaving that open, the High Court refused to entertain the PIL. However, the High Court stated, allowed the petitioner to file a representation before the LG and stated that we are not commenting on the merits of the case and we are not commenting on the merits of the representation as well. The LG might consider the representation at its independent consideration.
Okay. Okay. Rame, let me come back to you. Let me also get our viewers another update about Arvind Kejriwal. The Delhi Chief Minister, remember, has now moved the Delhi High Court seeking permission to increase the number of legal meetings that take place in a week and that he is permitted for. He's seeking to raise the frequency of these meetings from 2 to 5 on a weekly basis. In his plea to the Delhi High Court, Arvind Kejriwal has said that he's facing multiple FIRs in various states and therefore he has a lot of legal work that needs attention. Remember, Arvind Kejriwal has been lodged in Tihar jail since Monday in connection with the Delhi Liquorgate probe. He has been remanded to the ED's judicial custody until the 15th of April. Let me go back to Rame now for more details about this. Rame, the Delhi Chief Minister seeking to increase the number of meetings that he has in prison. But legally, help us understand, would he be allowed to do so by the court?
No, absolutely, it's not allowed. The law is same for everyone. We cannot, the jail cannot give indefinite meetings to an under trial prisoner. There is jail manual, there are rules which is same for every prisoner. There is limited number of mulaqats with the family or the legal team, whosoever it may be. There is limited interaction. The liberty is curtailed and it is curtailed in accordance with law. So obviously the law is well settled that the things would be followed as per the jail manual. However, challenging that only, he has now sought the permission of the court. He has sought direction on the Tihar jail authorities that please allow me to meet with my legal representatives more than 5 times, as I have a lots of case pending against me. I have a lots of legal litigations pending against me, and for that I need more and more time to interact with my legal team to actually get these cases disposed of and to actually be a part of the justice system. That is what is being stated. Remember earlier, while he was being remanded to judicial custody, he asked for a table and chair. He asked for 3 books, Bhagavad Gita, Ramayana, and how prime ministers think. And he also stated that I am diabetic, please allow me the diabetes medicines, please allow me the health equipment from which the diabetes levels can be checked. He had also asked for a special bed and homemade food, stating that he is suffering from high diabetes and only homemade food is allowed for him. However, these conditions were allowed, but still he has to again come to the court,
Yeah.
seeking permission, seeking direction of the jail authorities, as jail authorities do not allow such request, and they go as per the jail manual only. So today the court has issued notice in this application and has asked the Enforcement Directorate to reply by tomorrow. The court will consider, and if in accordance with law
All right.
and on humanitarian grounds, the court might grant such reliefs or might not. Over to you.
Okay, we'll have to see how it pans out for Arvind Kejriwal. Rame, thank you very much for joining us at the moment and helping us understand what all transpired in the court today related to Arvind Kejriwal and the ongoing Liquorgate probe. Now remember, as Arvind Kejriwal continues to remain